I suppose we can go ahead and get started. Before we begin our final round, um, I just want to say a little bit about our competition and everything we've had going on this past long weekend. This is the final round of our 2021 National Energy and Sustainability Competition that we host here traditionally at the WVU College of Law. But because of Corona this year, we have decided to do it on a virtual format. And hopefully people from all around are able to stream and watch our wonderful competitors argue. They've been putting in a lot of work to make it to this final round. Before we begin, I want to say, oh, I'm not sure if I introduced myself. My name is Bryce Phillips. I am the Chief Justice of the WVU Moot Court Board. And I did help on this competition, but there were a lot more people who did a lot more than I did in planning it and getting it all together. So I want to say a few thank yous to those people. Lauren Cyphers was our incredible Energy Moot Court chair behind the scenes. Dan Granfield was responsible for getting all our bailiffs together that kept time and kept our competitors on track. And Blake Humphrey was our judge liaison who was able to fill your rooms with wonderful judges who I hope gave you a challenge and made this competition a little bit more interesting for you. But without further ado, our teams that will be arguing in the final round of the 2021 Energy and Sustainability Moot Court Competition are the first representing the state of Vandalia is the University of Utah, and that will be argued by Natalie Beal and Stephanie Hanawalt. And our second team representing Commonwealth Energy is from St. John's University, and that will be argued by Ashley Williams. Oh, pardon me, Ashley Williams is their coach. That will be argued by Molly Sheehan and Stephanie Lemers. Our distinguished panel of judges today will be the Honorable Judge Abelhausen from the United States District Court of the Southern District of West Virginia, Judge Alloy from the Northern District of West Virginia, Judge Klee from the Northern District of West Virginia, and Judge Volk from the Southern District of West Virginia. They are really looking forward to sitting for you all and putting on a great final round of our competition. So without further ado, I will bring our judges into the room and we can begin. Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw near and give attention, for the court is now sitting. The case of State of Vandalia versus Commonwealth Energy will now be heard.
Good afternoon, Your Honors, and may it please the court. My name is Natalie Beal, and along with my co-counsel, Ms. Hanawalt, we represent the appellant, the State of Vandalia. The state would like to reserve 1 minute for rebuttal. Today, Vandalia asked the court to overturn the district court's decision ruling the Clean Air, Clean Jobs Act unconstitutional. I will be explaining why Title III of the Act does not violate the Dormant Commerce Clause and why Title V of the Act sets just and reasonable rates. And my co-counsel, Ms. Hannawalt, will be discussing the Supremacy Clause issues. Would the court like a brief recitation of the facts before I begin?
I believe that would be appropriate, counsel, in all candor. Thank you.
Vandalia is in an energy crisis, and in response, the state passed the Clean Air, Clean Jobs Act. The act has 5 primary elements. It adopted greenhouse gas reduction goals for the states, implemented renewable energy standards, and it phases out coal. The act also adopts a retail net metering program and prevents the aggregation of DERs, provisions that my co-counsel will address in a moment. The objectives of this act are to provide clean, affordable energy and to combat climate change. Turning to Title III, this court should overturn the district court's ruling that the Clean Air, Clean Jobs Act violates the Dormant Commerce Clause. In Dormant Commerce Clause cases, the dispositive question to ask is whether the benefits of a state law outweigh the burdens on interstate commerce. If a state law is facially discriminatory, then strict scrutiny applies. But if the law only has impacts to interstate commerce, then the Pike balancing test applies, which considers if the impacts are incidental, if there are legitimate local goals, and if the benefits—
Counsel, let me ask you a question. The act is requiring that these coal plants in Vandalia shut down by June or July of this year. How is that lack of time not unreasonable?
Your Honor, that lack of time is not unreasonable based on the market of the lifespan of coal power plants. And they have, in a study done by the US Information Administration, it stated that the average lifespan of a coal power plant was 46 years. And here these plants have been operating for more than 40 years. So Commonwealth has had adequate knowledge that these power plants are towards the end of their life cycle, and a transition to renewable energy would be necessary to continue to maintain their presence in the arena of energy. Title III of the Act is—
Ms. Bill, I have something. First, you started out your presentation indicating that the state of Vandalia was in an energy crisis. This legislation doesn't seem like an energy crisis bill to me. It seems like we just want a different type of energy and get rid of coal bill. So what evidence do you have that you're really in an energy crisis, or isn't this really about wanting to get rid of fossil fuels and go to renewable energy?
The state is in an energy crisis.
Okay, what evidence? Go ahead.
On page 3 of the record, it states that Vandalians were paying 4 times the national average for their energy, and the state needed to take action to stop those predatory rates. Additionally, Title I of the Act details substantial negative impacts the state has faced due to climate change, including floods that caused death to over 20 Vandalians, or storms that have made almost 700,000 Vandalians lose power. And climate change is absolutely a crisis that requires the transition to renewable energy. And the people of Vandalia were clear in this election that that's exactly where they wanted their state to go, towards clean energy. And here the state passed a piece of legislation that survives the Dormant Commerce Clause. The court has held that facially discriminatory laws are ones that ban or severely limit the flow of interstate goods.
So I just heard you say something. This is really a climate crisis bill. Wouldn't you say that more so than an energy bill?
The bill has provisions that address both the local energy issues, like high rates of coal and health issues associated with that, and additionally addresses larger climate change issues as well.
Okay, nothing wrong with that. Just say it. It's what the governor wanted to do, right? That's why they elected him.
Yes, that was a main—
I'm sorry, go ahead.
Yes, that was a major objective in this piece of legislation, was to combat climate change and to provide reliable, renewable energy. And the circuit courts have looked to the distinction of facially discriminatory versus where to apply the Pike balancing test. And based on those circuit cases,
Ms. Beal, I'm sorry. I'm glad you transitioned to that question, because something that I need explained to me is how this act is facially neutral, given the clear preference bestowed upon clean energy programs, clean energy job creators within the state of Vandalia as compared to elsewhere.
here, Your Honor, this is a facially neutral law, and the Pike balancing test should be applied by looking to the distinctions circuit courts have made in the arena of renewable energy legislation. In North Dakota versus Haydinger, there was a challenge to a Minnesota law that prohibited and banned the importation of energy that would increase the state's greenhouse gas emission. And there, the court held that that was facially discriminatory. But where this law is much more similar is to the Connecticut renewable energy portfolio looked at in Alco v. Klee. And there the court upheld Connecticut's portfolio that required a certain percentage of renewable energy, and that could be achieved by purchasing renewable energy credits from within the region. And
Well,
here,
but the difficulty is, I'm sort of with Judge Klee on this. How do you contend Title III in particular doesn't discriminate on its face? The plain language seems to evidence geographical discrimination, and I think you could achieve your goals in a different way. If you get to strict scrutiny, you lose. Is that not correct?
no, Your Honor, the act could still survive against strict scrutiny. There's no denying that that is
Title III? Title
yes, Your
III?
Honor.
Okay,
There-
explain that to me.
Yes. There's no denying that strict scrutiny is a high burden to overcome. And in fact, only one Supreme Court case, Maine v. Taylor, has survived strict scrutiny. However, that case is critical because that was an environmental regulation case. And the court there said that regulations that concern local environmental resources should be granted deference. And here, that deference would also be granted, as well as Title III really works as a subsidy. It's the solar renewable energy credits that are working to provide subsidies to incentivize a transition to renewable energy credit. And in New Energy Co. versus Limbach and in Westland Creamery versus Healy, the Supreme Court held that subsidies do not violate the Dormant Commerce Clause. And so there, this act very well could and would survive strict scrutiny. However,
But do those cases involve similar legislation where I think there's just the clear intent that was announced in the language itself of preference based on geography and state boundaries?
yes, Your Honor, those cases are regarding different specific subsidies. They're not renewable energy credits. But states can favor their own citizens through subsidies, which is what the state is trying to achieve here. And the dispositive question to look at in the Pike balancing test are if the burdens are outweighed by the benefits. And here, the burden we're talking about is 0.2% of solar energy requirement. But the benefits that Vandalia can receive from combating climate change are massive. The legislative history details the detrimental effects that Vandalia has endured because of climate change. Appendix A, page 1, talks about how climate change had massive negative impacts on the largest segments of Vandalia's economy, on agriculture, on forestry, on tourism. And climate change has also impacted the infrastructure and exacerbated air pollution, which has increased incidences of infectious disease, of asthma, of heart attacks. And states, under their police power, have the ability and the responsibility to govern for the safety and the well-being of their citizens, which is exactly what Vandalia is trying to do here. And
Counsel, if you had to make your
That's
best
awful.
argument, if you had to make your best argument right now as to why we do not have a facially discriminatory geographic distinction, just tell me in 2 sentences why this is not going to be subject to strict scrutiny.
here, Title III, Your Honor, is silent to out-of-state producers. There are no bans on out-of-state producers entering the market, and they're free to compete in this arena. Rather, there's a small subsidy provision.
Don't they have to be headquartered in Vandalia or connected to Vandalia somehow.
Or they could purchase the solar renewable energy credits if they didn't wish to move into the state.
So on day one, we're making a distinction between the two, are we not? They have to come.
No, Your Honor, they don't have to, because they could achieve the portfolio requirement by purchasing the solar renewable energy credits, which is exactly what the court looked at in Alco v. Clee and said that using those renewable energy credits was a permissible way to effectuate a goal of transitioning to renewable energy.
Do those credits have to be that they originated in Vandalia?
Yes, those subsidies, Your Honor, are only available to Vandalian citizens. And equally as important to the state's objectives of providing clean and healthy air is reducing the use of coal, which Title V achieves. Title V directs the premature retirement of all coal power plants and is a constitutional exercise of the state's authority and is not a taking under the Fifth Amendment. Here,
I'll go with Judge Volks. Tell me in 2 sentences how that's not a taking. If I have a car that I purchased and all of a sudden the law gets passed that says you have to trade in or quit using that car after 5 years, even though it may have another 10 years left on it, how's that not a taking?
it's not a taking because this is a rate-making issue, which has its unique framework set by the Supreme Court, which requires a standard of just and reasonable rates to be paid. And here, Title V achieves the balance of utility and customer interests, which is required under the dispositive Hope test. And here in Federal Power Commission versus Hope v. Natural Gas, the court held that in setting just and reasonable rates, the state has a responsibility to adequately consider both the investor and consumer interest, but the state also has a responsibility to protect their citizens from exploitative rates. And here,
I think Judge Alloy had a question for you as well. I don't want him to miss that opportunity before we close.
Well, there's a general question which is this legislation basically says that the state is taking over, I mean, energy production in the state of Vandalia, because you're getting rid of coal and you're dictating what it has to be. Can you do that?
yes, here, Your Honor, it is phasing out coal. That is what the legislation requires. But the reason why Vandalia is going to pay Commonwealth Energy $780 million is so they can continue to be participants in the energy market by transitioning to renewable energy. And in doing so,
but Ms. Beal, I'm sorry not to interrupt, but I mean, does our constitutional and the constitutional restrictions on the government's exercise of this type of authority, they're picking winners and losers. I mean, does our Constitution permit the government to do that?
Under rate making, Your Honor, it's an adequate balance of investor and citizens' interest. And the requirement is that the rate that utilities should be paid should be reflective of the corresponding risks of their enterprise. And here, any loss Commonwealth Energy endures is representative of the fact that coal is no longer the cost-effective venture that it once was.
Only because of this legislation and similar legislative efforts elsewhere. The government has decided that it's no longer cost effective because they've imposed these new burdens on an industry. As you mentioned, the power plant at issue, one of the power plants at issue, has been operating for over 40 years.
Yes, Your Honor, it has been in existence for 40 years, but the record details that Vandalians were paying 4 times the national average for their energy, and states have a responsibility under this takings framework to make sure that utilities are not earning so much that they charge predatory rates for citizens, which is what Vandalia was trying to protect. And the Clean Air, Clean Jobs Act revolves around local issues that require local solutions. The act is a constitutional exercise of state power, and it effectuates the will of the people of Vandalia to provide clean air, transition to renewable energy, and to combat climate change. For these reasons, this court should overrule the district court's finding. Thank you, Your Honors, and I will turn my time over to my co-counsel.
Thank you very much, Ms. Beal. Ms. Hannah Walt, you may proceed whenever you're ready, ma'am.
Thank you, Your Honor. May it please the court, my name is Stephanie Hannawalt, and I, along with Ms. Beal, represent the appellant, the state of Vandalia. And I will be discussing why Vandalia's net metering program and its prohibition on the aggregation of distributed energy resources falls squarely within a state's authority to implement. Would the court like a brief recitation of the facts related to the Supremacy Clause issues before I get started?
I think that might be helpful, so please proceed.
Of course. The Clean Air, Clean Jobs Act was enacted to move the state of Vandalia toward cleaner, renewable energy and a more reliable energy system. My co-counsel discussed two provisions of the act that further this goal, and I will be discussing the two others. First, Vandalia's net metering program provides credits to customers who add renewable energy to the grid, typically through the use of solar panels, and these credits are provided at the price of retail. And second, Vandalia's prohibition on the aggregation of DERs was an amendment to the act in response to FERC's issuance of Order 2222. The order sought to remove barriers to DER participation in the wholesale energy market. Vandalia made a finding that its ability to maintain a safe and reliable distribution system would be barred by that order, and so the act prevents such an outcome before it can occur.
Ms. Hannah, I'm glad that you mentioned FERC, because one of the things that jumped off the page to me with respect to the Supremacy Clause issue is FERC's multiple defeats over in the DC circuit. Why is this case? How is this case different?
Yes, Your Honor. So the DC Circuit's decisions were talking about a completely different situation than we're talking about here. Those DC Circuit decisions, Calpine and SoCal Edison, those were referring to whether or not FERC can establish jurisdiction based on the length of a net metering program. And here we're not talking about the length of the net metering program, we're talking about these credits. And these credits, because these are retail transactions, they fall within the state's purview under the Federal Power Act to regulate. And so with that first provision, Vandalia's net metering program, it does not violate the Supremacy Clause for three reasons. One, which I just mentioned, it's rightly within a state's retail authority to control such programs and the rates within. Two, states have control over intrastate wholesale transactions. And thirdly, as a matter of policy, states should have control over their own net metering programs and the rates charged in those programs because they're inherently local programs.
So Ms. Hannawalt, help me understand this. Go ahead, Mr. Abelhausen. You're the judge with the solar panels on your roof.
Why don't you say, is it your contention that the electricity that's generated from these solar powers doesn't affect interstate commerce in any way whatsoever when it goes into the power grid? I mean, we're not talking about Texas that has their own power grid, and we saw what happened to them a few weeks ago. We're talking about the power grid in this part of the country. Doesn't it go into multiple states when I produce that power from a solar panel?
Your Honor, it may have some effect on interstate commerce, but it's impossible to tell where the energy is going once it leaves the solar panel on a particular customer's roof. These entities produce so little energy that it's very unlikely that the energy will leave the grid in Vandalia and go to other states and supply the nationwide energy market or the energy market supplied by PGM interconnection.
What if I live in a border county right next to another state? Right on the line. I mean, you can't tell me that electricity is not going to cross the border.
Your Honor, it's inherently you just can't determine whether the energy is crossing the border. There are more reasons here why this constitutes a local and intrastate transaction rather than an interstate transaction, because the only way that it would become an interstate transaction is if we could trace that energy and figure out whether it crosses borders. But because here these credits are constituting retail transactions, they fall within the purview of states. And so Commonwealth is arguing that these transactions constitute wholesale transactions and should be within the authority of FERC. But that's simply not the case. The transactions here are just an exchange of credits. They're not a resale of some kind. And the Second Circuit looked at whether credits fall into the retail authority of states and determined that credits like zero emission credits, which were at issue in that case, are separate from a wholesale charger rate because it was a certification of an energy attribute. And the credits in Vandalia's program are the same. The state's rewarding generators for contributing renewable energy to the grid by providing credits on their electricity bills. And to your point, Your Honor, even if the court were to find that these credits do constitute wholesale transactions, the Act gives states jurisdiction over interstate wholesale transactions, which brings me to reason number 2. The sale here is occurring between a local customer and a local utility. The transaction's wholly intrastate and under the state's jurisdiction. And the Federal Power Act has expressly precluded FERC from exercising jurisdiction over facilities used in local distribution.
Ms. Hannawalt, I did want to ask you a question because you suggested that if there is any energy leaving the state, thus becoming interstate, that it was de minimis. But is there any evidence in the record that indicates Vandalia now, how much of these rooftop solar panels, how much excess energy are they producing? Or is it all just enough for their own homes? Is there anything in the record that addresses that?
Your Honor, on page 5 of Appendix A of the record, Title IV discusses not specifically how much energy these facilities are producing, but the fact is that the net metering program caps the amount of energy at 3% that these entities can produce of the utility company's total amount produced. And so because of that, they're inherently limited to producing small amounts of energy. And to that point specifically, FERC's Order 888 addresses whether utilities are local entities that constitute low voltage entities that are within the purview of states. That order looked at 7 factors in determining whether an entity is a local producer of energy, and 5 of 7 of those factors apply here. The first is when the facilities are in close proximity to retail customers, and here they are on the customer's property. When the energy is transported to other customers on the local grid, and here this energy is serving local customers on Vandalia's grid. When the power is entering the local distribution system and is consumed in a small geographic area, and because these are small entities, their voltage is low and their energy doesn't translate as far on the distribution lines. And 4 and 5 are when meters are based at the transmission interface, which here they're located on the customer's property behind the meter. And lastly, when local distribution systems are of reduced voltage, as I mentioned previously, these are small entities producing very low energy.
So Ms. Hannawalt, it seems, I mean, how critical is this part of the legislation to the governor's vision, keeping really the feds out and leaving it local so Vandalia can control their own energy policy? How critical is this piece of it?
This piece of Title IV is critical to furthering Vandalia's renewable energy goals because it incentivizes consumers to put solar panels on their roof and participate in the program, thus providing more energy to the grid and providing more opportunities for lower rates for people within Vandalia. If there's more energy producers, that lowers rates for entities within Vandalia. And in the
Counsel, let me ask you this question, and I'm aware of FERC's order and the rest, but I mean, is there a minimum gigawatt, megawatt requirement before something is considered inter versus intrastate commerce? Is that something this court has to determine? Because I'll be honest, I'll confess my ignorance. I don't feel qualified to do that.
Yes, Your Honor, there's no need to determine what megawatt of energy is required to determine whether this is intrastate or interstate. That would likely fall within the purview of FERC if FERC did determine that it wanted to exercise jurisdiction over net metering programs, which it has not done so. So here what the court needs to look at is whether under the Federal Power Act, its division of authority between the states and the federal government, whether this constitutes a retail transaction or a intrastate wholesale transaction. And because it could be qualified as both, it should fall within the purview of the states to enact this program.
If you follow the logical extremist, Hannawalt, of your argument, and if every other state does, FERC is out of the solar panel business on homes, right? They just can't say anything about it. No jurisdiction.
Yes, Your Honor. FERC has not felt the need to exercise jurisdiction over local solar panels because they do not affect the interstate wholesale market. FERC had the ability to address net metering programs in the New England Ratepayers Association case. That FERC was confronted there with the same issue the court is facing now as to whether or not FERC has jurisdiction over net metering programs, and FERC declined to exercise any jurisdiction there or even decide the case. And so if it wanted to exercise jurisdiction over net metering, it had ample opportunity to do so when faced with the case in New England Ratepayers Association. And so for those reasons, the ability of states to regulate their own retail net metering programs is inherently important. Federal law does not preempt state law here because FERC has not spoken to this issue and has neglected to extend jurisdiction over it. And if it wanted to do so, it could have in New England Ratepayers Association. In the same manner, the second provision, Vandalia's ban on the aggregation.
So let me ask you, you say though that FERC has declined to exercise jurisdiction. I mean, the logical extension of your argument is that perhaps they can someday. I mean, is that true?
Your Honor, FERC has not claimed jurisdiction over net metering programs, but it has disclaimed jurisdiction over net metering programs. It specifically stated in Order 2003-A that net metering programs, when the customer is producing more energy than it consumes, that does not implicate the Commission's jurisdiction. And so it has not specifically stated whether or not it's going to exercise jurisdiction over net metering programs, but it has stated that it will not be exercising jurisdiction when that's the case, when there is a net sale of electricity.
In this question, I guess, may not be necessarily germane to this, but is that question about which FERC has jurisdiction up to FERC? Should that be something Congress addresses?
Your Honor, Congress enacted the Federal Power Act to address this question, and FERC is charged with implementing Congress's directive in that act. And so here, because FERC has the jurisdiction and should be awarded deference as to its decision whether to exercise jurisdiction, the court should not defer to wait for Congress to decide this issue. And in the same manner, the second provision, the DER ban, falls within Vandalia's authority over their retail market. Vandalia here is not regulating the wholesale market itself, but only the terms of access to the local market and the safety and reliability of its own grid. And the Order 2222 specifically recognizes this, stating that nothing in this final rule preempts the right of states and local authorities to regulate the safety and reliability of the distribution system. And that's exactly what Vandalia seeks to do here, allowing DERs to aggregate, join the wholesale market, and be a producer of energy for the citizens of Vandalia as small entities is not a risk that Vandalia is willing to take. And it's within Vandalia's purview to do this, as Order 2222 states, to avoid such an outcome. And so the language of Order 2222 here creates a carve out for states, allowing states to continue to maintain the safety and reliability of their own distribution systems without being preempted by the order. And as the Supreme Court stated in an Electric Power Supply Association versus FERC, FERC cannot take an action transgressing state authority, no matter how direct or dramatic its impact on wholesale rates. And so here, because FERC provided that carve out for states when they act in favor of the safety and reliability of their own grids, the order here does not preempt Vandalia's Title VI. And for those reasons, Vandalia asks the court to reverse the district court's decision in favor of Commonwealth and find that the act is a constitutional exercise of state authority. Thank you, Your Honors.
Thank you.
Thank you, counsel.
May I proceed?
You may, counsel. Thank you.
Yes.
Good afternoon, Your Honors, and may it please the court. My name is Molly Sheehan, and I, along with my co-counsel, Stephanie Lemurse, represent the appellee Commonwealth Energy. I will be discussing how the state of Vandalia violated both the Dormant Commerce Clause and the Takings Clause, and Ms. Lemurse will then discuss how Vandalia violated the Supremacy Clause. Your Honors, a law like the Clean Air, Clean Jobs Act may have broad public support, and it may be well-intentioned, but that does not make it immune from complying with the United States Constitution. Therefore, Commonwealth Energy requests that you affirm the district court's ruling in granting their motion for summary judgment.
Well, first of all, we don't have to give the district court any deference, do we? What's the standard of review?
Your Honor, that is true. The standard of review is de novo, but we believe that the district court was correct in its findings as to the 4 issues here. And to the
And for the record, generally the district judges are infallible, and I would agree with that. But academically, it is de novo review, right? We don't have to listen to anything they say.
That is correct, Your Honor. It is de novo, and you do not have to give the district court deference, but Commonwealth Energy's position is that the district court was correct. And in particular, I will be discussing how the district court was correct in finding Title III, Section 11 violated the Dormant Commerce Clause, and how Title V violated the Takings Clause.
Sure. So what is so wrong about the state of Vandalia wanting to get some control over their energy policy rather than leaving it to the energy barons and haven't been very kind to our state for a long time?
Your Honor, what the purpose of the Clean Air, Clean Jobs Act is doing is laudable, but they cannot achieve these goals by discriminating against out-of-state entities. And that is what they're specifically doing with Title III, Section 11, and not allowing out-of-state companies to receive solar renewable energy credits. This law violates the Dormant Commerce Clause, which states that a law that discriminates against or unduly burdens interstate commerce is unconstitutional. And there are 2 types of laws that violate the Dormant Commerce Clause: laws that are facially discriminatory and laws that are facially neutral, whose effects incidentally burden interstate commerce.
Well,
Now,
but let's hold on there for one moment. I understand that you want to advocate very, very strongly for strict scrutiny here, but let's say that we conclude that Pike's going to control this matter. Are you telling the court that Vandalia doesn't have a legitimate local interest in protecting the health and safety of its citizens?
Your Honor, if Pike did apply, Vandalia does have an interest in promoting the health and safety of its citizens, but that interest is the burden on interstate commerce outweighs that interest. Vandalia offers as legitimate interests the protection of the environment.
If the health and safety of the populace, the state under its police powers at a minimum, regulating that and seeing to that, if that is going to be outweighed, what interest could ever counterbalance the burden that you're speaking of?
Well, Your Honor, looking at what Vandalia's goals are here in this case, these are things that are not limited to Vandalia. Of course, they are free to legislate for their own citizens as they see fit, but climate change and renewable energy are issues that transcend the state boundaries of Vandalia. So if Vandalia really wanted to promote the local interests, they would allow for these out-of-state companies to receive these solar renewable energy credits and allow them to allow these out-of-state companies to put even more clean energy into the state of Vandalia.
Ms. Sheehan, let me, if I could piggyback off of Judge Volk's, I think, very probative question. You've convinced me with your answer on that, but where I get hung up is this opportunity for Commonwealth or other similarly situated entities that may not be domiciled or established or founded within the boundaries of the state of Vandalia, but you can purchase credits basically to gain the state's forgiveness.
That's correct, Your Honor. Could you clarify what exactly you're asking with that?
The solar credits. You've convinced me that absent these solar credits that could be purchased, that we've got unfair protectionism at play here. And although it may be a legitimate interest, as Judge Volk mentioned, to protect the health and safety of its citizens, you, I think, properly mentioned that Vandalia is not the lone territory that suffers from the alleged negative impacts of climate change, but they've built in these solar credits for companies that are not native or domiciled to the state of Vandalia. How then is Commonwealth Energy disproportionately or disparately impacted here?
Your Honor, they're disparately impacted because their subsidiary that are located in West Vandalia and Franklin, they are ineligible to receive these credits. And furthermore, they are not only excluded from the market, but they have no market for solar renewable energy credits at all. And they do have a market for renewable energy credits, but renewable energy credits are not worth as much as solar renewable energy credits. So they are not only precluded from participating in the Vandalia market and receiving solar renewable energy credits, they do not have any other recourse to receive any solar renewable energy credits in their own states. So that's how they are disparately impacted here.
But Ms. Sheehan, what is a state to do? I mean, are they completely powerless to protect their own people, the governor, their own constituents from the effects of climate change, which has really ravaged the state? I mean, are you just saying that the state is powerless, can't do anything, don't waste your time doing any legislation because everything in energy is interstate commerce?
Your Honor, the states are not powerless, and Commonwealth Energy is not advocating for Vandalia to only reserve these solar renewable energy credits for out-of-state companies. Commonwealth Energy's request is that they remove the location requirement and allow, along with the utilities located within Vandalia, to allow these companies located outside of Vandalia to also receive these solar renewable energy credits.
But then there's no incentive for anyone to build clean energy within the state, and that's the problem. And is that just tough?
Well, Your Honor, I think it's important here to look at the Clean Air, Clean Jobs Act as a whole and not just Title III. In Title V, which I will speak about further, that is requiring the retirement of coal plants. So industries within Vandalia are already going to have to transition to types of renewable energy, whether it's solar, hydroelectric, or wind energy, given the closing of the coal plants, Vandalia has historically relied on coal energy. So
Well,
here,
but you don't like how the governor did, you don't like how he addressed that issue in sort of phasing out the coal, right? I mean, you're not agreeable to that either.
respectfully, Your Honor, that is a separate issue, which I can move to now. With Title V, it should be noted in the record that it does not say that Commonwealth Energy is challenging the actual retirement of these coal plants. They're merely challenging the compensation they are receiving for the forced retirement. And the fact that they are not challenging whether the retirement of the coal plants indicates that Commonwealth Energy understands the situation both in Vandalia and the world. States have been moving away from coal energy for a while, and that's important. Looking at just what happened in Texas, there's a shift that needs to happen from coal energy. So Commonwealth Energy does understand that. But what Title V is requiring is that these plants retire by July 1st, 2021, which is in a few short months, and they are only allowed to receive 50% of their the net book value of the 3 plants that are being forced to retire, which are Raven, Hunter, and Fort Duquesne. And the Federal Power Commission versus Hope provides a balancing test, as the appellant stated, which looks at the investor interest balanced against the consumer interest. Here, with Title V, it's clear that the consumer interest was accounted for. Vandalia wants to shift away from coal energy and into a more clean energy. But there is no evidence that any of the investor interests were accounted for at all.
Well, the consumer interest indicates that they're paying 4 times in energy what surrounding states are. I mean, is that correct? That's what they represented. That's what Vandalia represented.
Your Honor, that is correct, but the net book value of these 3 plants that combined that are being forced to retire is around $1.4 billion. With this, with Title V, they're only allowed to recover 50% of that amount.
So your argument is that consumers need to bear the cost of what is now an inefficient energy source.
No,
rather than the business entity.
And I would say too, counsel, just pivoting off of my colleague's observation there, coal's been on the decline for many, many years, and many companies have been switching to clean energy and more environmentally friendly alternatives. So how can you really classify your investments in these coal plants as prudent?
To answer the first question, Your Honor, Commonwealth Energy is not putting the burden on to the consumers here. all the test requires that the consumer interests are balanced against the investors. And we're not saying that the consumer interest should not be taken into account. They should, but the investor interest should also be taken into account. And to Judge Volk's question, the investors here, coal industry has been on the decline and they're aware of that, but Commonwealth Energy included into their portfolio for the next 10 years of that these three plants were intending to be lucrative. And the Vandalia Public Service Commission approved that in their financial portfolio for the next 10 years. So given that coal has been historically a successful forms of energy within Vandalia, Commonwealth Energy has been providing a public service consistent with what the Vandalia needs. And now that's
Hasn't these power plants been in operation for over 40 years, which when they were constructed, their life expectancy wasn't much more than 4 years, correct?
That is correct, Your Honor.
So they've almost lived their life expectancy, and you're upset because you're going to get credit for half the value, the book value of these properties, when you've gotten almost 100% use out of it.
Your Honor, what I think you stated the problem here is that the 46-year life expectancy, we're only at year 40 now. So these plants would have had the opportunity to continue to be profitable, but Vandalia is stripping. Sorry.
Life expectancy another 6 years. But if you want 50%, the 50% credit on the book value of these plants, that's greater than what the actual life expectancy. I mean, we've got 6 years out of 46 years, right?
Your Honor,
question.
Your Honor, regarding the life expectancy, there's nothing in the record indicating what actually Commonwealth Energy would have been receiving if they did go their entire life expectancy. But here, with the forced retirement of the three plants, Vandalia just chose an arbitrary number, and the Permian area rate cases says that arbitrary rates are unconstitutional. Vandalia provided no explanation as to why 50% was the number, and it seems they're strictly trying to punish Commonwealth Energy for being a coal industry, which they're trying to move away from.
Or maybe the governor's trying to say they'd come to the game probably about 30 years too late. So they got to get moving.
Your Honor, Vandalia has relied on coal energy, and Commonwealth Energy has been providing this service as the coal service to the citizens of Vandalia since 1935. So they had no reason to shift their energy because Vandalia has relied on it, and there haven't been. Governor Green did not raise these issues until her campaign in 2020. So, given that Commonwealth Energy has been a historically successful company, and looking at what their investors have put into the company, they deserve to receive more than just 50% of their return on their investment.
Let me ask you, how does the Bluefield Waterworks case, the precedent set by the Supreme Court in that case, compare to the facts in this case?
Your Honor, the Bluefield case was clarified by the Federal Power Commission versus Hope, so it is not necessarily binding precedent, because Federal Power Commission versus Hope said that the test is the investor compared to the consumer interest. And here, just the Commonwealth Energy's investors' interest was not accounted for here. And this is a broader problem because it indicates that if a company has a service that may be replaced down the line by something better, the state is essentially saying, because this is no longer popular, they will not receive a fair return on their investment. And I see my time is up, so thank you, Your Honors.
Thank you.
All right, thank you very much, counsel.
May I
Ms. Murphy?
proceed?
You may, ma'am. Thank you very much.
Good afternoon, Your Honors, and may it please the court. My name is Stephanie Lamers, and as my co-counsel stated earlier, I will be discussing the Supremacy Clause issues before this court. The appellee respectfully asks this court to affirm the lower court's ruling because this is a paradigm case of where the state has exceeded its bounds of authority. Vandalia's enactment of Title IV and Title VI of the Clean Air, Clean Job Act grossly violates the Federal Power Act and the Supremacy Clause of the United States Constitution for the following two reasons. First, Vandalia's adoption of the net metering program infringes on FERC's exclusive jurisdiction over wholesale transactions.
Council, let me ask
Second,
you about that. If we adopt your position on that, don't you make consumer purchasing of solar panels for home use very unattractive at that point if they can't get credit at the retail rate?
no, Your Honor.
Isn't
No.
that the goal? Isn't that the goal of your client, of Commonwealth Energy, to make that less attractive?
No, Your Honor. Commonwealth Energy acknowledges the state's interest in incentivizing its citizens to use more renewable energy resources. However, that interest does not safeguard and protect the state from infringing on the federal government's exclusive jurisdiction over wholesale transactions. And when
So that's a fundamental question that I have, Ms. Lemers. Is that what evidence is there in the record that there's any kind of wholesale impact or impact on interstate commerce coming from the roofs of solar panels on little homes in Vandalia? Or is that all just sort of anecdotal? I mean, do you have evidence in the record that shows how it's affecting the wholesale market in interstate commerce?
I would join that question, Ms. Lemers, and it's central to what we're addressing here today. We're talking about relatively small quantities of voltage energy that's transferred back. I'm not sure that really justifies preempting state jurisdiction, especially in light of FERC's decisions to decline to exercise federal jurisdiction over these net metering systems.
Your Honors, the appellant incorrectly miscategorizes the net metering program we see under Title IV. As we see on page 8 of the record, Vandalia's program is regulating customer-generated production by renewable energy resources. However, the appellant fails to note that when these customer generators are producing exports, which are considered net positives, or when a customer generator is producing more energy than he or she consumes, the electric utility companies are obligated to purchase these customer generated exports at either the electric utility's full retail rate, at the electric utility's full retail rate. So there's a transaction that's occurring between these customer generators and electric utility companies. And when the electric utility companies purchase these customer generated exports, they're being returned to the electric distribution systems and then being sold or resold to electric utilities' other customers, plausibly in interstate commerce. So as we see on page 11 of the record,
that's your burden to establish. You said possibly. Where's the evidence that it actually is?
I'm sorry, Your Honor, can you please repeat your question?
You said could possibly be affecting interstate commerce. That's your burden to show that it is affecting interstate commerce. And to come here and say that it's possibly affecting interstate commerce, doesn't that take away your argument? Because you can't show that it actually is affecting interstate commerce.
No, Your Honor. The Supreme Court in Hughes versus Talent Energy Marketing affirmed that FERC has exclusive authority over the sale of electric energy at wholesale and interstate commerce. And the court defined a sale at wholesale as a sale of electric energy.
I don't mean to belabor this point, but didn't FERC specifically not exercise jurisdiction on the retail market of these credits?
Your Honor, the cases where FERC has declined to assert jurisdiction are of limited rulings and do not change the outcome of this case. For instance, the appellant miscategorizes the precedent regarding FERC's jurisdiction and relies on, for instance, New England Ratepayer Association. In that case, FERC declined to review the case because of a factual dispute and because the claim was not brought by an identified source. The more relevant case law is Calpine and SoCal Edison, where the court ruled that when a customer generator is producing more energy than he consumes, that known as a net positive, FERC's explicit jurisdiction is triggered. And SoCal Edison, the court also held that no retail sale exists where there is an export because customer generators are selling back the energy to these electric utility companies, not end users. And Hughes versus Taylor and Energy Marketing, the Supreme Court also examined a Maryland program that guaranteed a different rate than the rate that was set by the wholesale power markets, which adjusted and had an effect on wholesale rates. And there, the court ruled that there was an infringement on FERC's exclusive jurisdiction. The facts of this case are comparable because as we see on page 8 of the record, Vandalia sets the rate of these exports at the full retail rate rather than the appropriate wholesale rate. And when we're considering Supremacy Clause challenge, the Supreme Court in Rice v. Santa Fe Elevator Court ruled that any state law that occupies an area of law that the federal government has exerted its explicit jurisdiction must be preempted or superseded. And when considering whether or not a state mandate is preempted or superseded, the courts look to congressional intent. Here, Congress intended for FERC to have exclusive jurisdiction over the transmission of electric energy and interstate commerce and the sale of electric energy at wholesale and interstate commerce. And a wholesale sale is defined as a sale of electric energy for resale.
So the question, once again, where's the evidence that this is actually affecting interstate commerce? You said it possibly affects interstate commerce, but you don't have the proof that it actually does.
Your Honor, the record speaks on this issue on page 8, I believe. And in the record, it says that when you have a customer generated export and when you're using electric energy, there's no way for this energy to be stored anywhere. So it has to continue to move, and there's like a flow of this. So when a customer generator is producing more energy than they consume, it's a plausible assumption to conclude that this energy is being resold to other customers. And when there's a resale of electric energy, that triggers FERC's exclusive jurisdiction in that regard.
So de minimis the amount of electricity that those solar panels are generating compared to the energy the company generates, that you're talking about a minuscule amount that might be going interstate, but it could very well be consumed locally with such a small amount of electricity being produced. You have no evidence that it affects interstate commerce.
Your Honor, admittedly, the record is silent as to the amount of electric energy that's being transported into interstate commerce. However, the record is also silent as to how frequent these exports are occurring. So similar to how the appellant makes the plausible conclusion that there may be a minuscule effect on the interstate commerce, it's also a plausible conclusion that there may be a significant effect in interstate commerce. And when we're considering the definition of what a wholesale sale is, whenever we have that resale of electric energy, that warrants FERC's exclusive jurisdiction. And Vandalia was improper for setting that, for setting those exports at the electric utilities for retail rate, rather than conferring and deferring to FERC's exclusive jurisdiction in that.
As a practical matter, Ms. Lemurse, I mean, I understand the history of the act, and really at that point in time, we didn't have solar panels. You know, you might have had fireplaces that kept your house warm, but it wasn't going back into the market. But does FERC really want to get into the regulation of solar panels on a residential roofs? It's one thing to do utility companies, but this just seems too much.
Your Honor, it's not FERC's, it's not Commonwealth's position to conclude that FERC is asserting its jurisdiction and net metering programs that are wholly within retail distribution systems. Admittedly, if the state is regulating a retail matter, then FERC will not assert its jurisdiction. But here we have a net metering program that infringes on FERC's exclusive jurisdiction on wholesale transactions. And when that occurs, under the Supremacy Clause, the states are not safeguarded from constitutional challenge. And as to my second point, Title VI of the Clean Air, Clean Job Act also must be preempted under the Supremacy Clause because it directly conflicts with FERC's Order Number 2222. And FERC's order, it unambiguously granted the distributed energy resources the right to participate in the wholesale power markets in the aggregate. Congress entrusted FERC with the duty to preserve the integrity of these wholesale power markets and sustain just and reasonable rates. And due to distributed energy resources' small size and the makeup within the power markets, they are subjected to discriminatory and unjust practices. So pursuant to the duty Congress granted FERC, FERC concluded that after extensive investigations, that in order to foster just and reasonable rates, DRSs must have the right to aggregate in these power markets. Additionally, the appellant fails to note that FERC considered to include a state opt-out provision. However, they declined to include one because they considered the policy considerations here, and they ruled that the state's interest to have a say in this matter must be outweighed by FERC's duty to ensure the integrity of the wholesale power markets. And also in FERC versus Electric Power Supply Association, the Supreme Court also addressed a similar provision, Order Number 719, which did include a state opt-out provision. However, unlike the opt-out provision we saw in Order Number 719, FERC deliberately refused to include a similar state veto option. Therefore, this measured decision to proceed without a state opt-out provision suggests FERC's assertion of its exclusive authority to regulate this matter. And FERC's decision to regulate this matter on its own and not include a state opt-out provision warrants deference from this court. The Supremacy Clause dictates that Vandalia is preempted from taking non-conforming positions regarding any state mandate. And here, Vandalia's Title VI explicitly conflicted with FERC's issuance, which permitted the right of distributed energy resources to participate in the wholesale power market and the aggregate. Therefore, implying that that's unreasonable and warrants this court to affirm the lower court's ruling. Unlike the appellant's misplaced position, FERC has not exceeded its authority by declining to include a state veto option. There's nowhere in the record nor precedent that says that FERC is required to include a state opt-out provision, especially considering matters that affects FERC's duty to preserve the integrity of the wholesale power markets and to ensure that participants aren't being subjected to discriminatory practices within these markets. So FERC didn't act unreasonably by concluding that the state's interest must be outweighed by policy reasons. And in fact, the state was the one that acted unreasonably by directly conflicting a federal mandate.
Mr. Mark, not to interrupt, but let me ask you, you mentioned that FERC was reasonable in its conclusion. Is that the standard this court has to apply in whatever amount of deference we are obligated to give to an administrative agency such as FERC?
Your Honor, in terms of the standard that federal agencies are required, the courts usually consider Chevron deference. And here, FERC's order not to include a state opt-out provision was neither arbitrary nor capricious. The court, FERC considered the state's interest, but ruled that their duty to ensure the integrity of these power markets outweighed the state's interest in this regard. And when we're considering public policy concerns, this court is implored to affirm the lower court's ruling. According to page 11 of the record of Appendix D, Vandalia was aware that the aggregation of distributed energy resources was subjected to FERC's exclusive jurisdiction. However, Vandalia stated, and I quote, that whether or not distributed energy resources have the right to participate in the wholesale power market is within the state's exclusive province. the state's position is that they are in the best position to, I see that my time is up. May I please have leave to conclude?
Absolutely. You may finish that thought, ma'am.
Thank you. The state's position is that they are in the best position to determine what's best for aggregators. However, Congress is in the best position, and Congress did authorize FERC to do what's best for the wholesale power markets. And for those foregoing reasons, we ask that this court affirm the lower court's ruling. Thank you so much.
Thank you.
All right. Thank you, counsel. I know there was time reserved for rebuttal. Ms. Hannah Waltz, if you're taking the lead on that, you may proceed when you're ready.
Thank you, Your Honors. On rebuttal, the state will briefly respond to 2 points. First, Commonwealth argues that, quote, whenever there is a sale for resale, it is within FERC's jurisdiction. But this is an incorrect characterization of the Federal Power Act. 16 U.S.C. Section 824 explicitly states that intrastate wholesale transactions are within the purview of states. And similarly, Commonwealth has not shown that these small entities producing low voltage electricity implicate the interstate wholesale market in any way. And further, Commonwealth does not respond to the fact that FERC created an explicit carve out, leaving to the states the ability to maintain the safety and reliability of their grid. And further, Commonwealth argues that the state implicated that the opt-out provision provides some kind of argument there, but the state did not argue that the opt-out provision is supportive of our argument in any way. FERC is not entitled to Chevron deference under the Federal Power Act unless the statute is ambiguous, which it is not here. And for those reasons, we ask that you reverse. Thank you, Your Honors.
Sorry, couldn't find my unmute button. Thank you very much, counsel. The matter will be considered, argued, and submitted for consideration, but I, of course, will, as always, follow the directions of our bailiff, Mr. Phillips.
Thank you, Judge Clee. Great job, everyone. I'm going to put our judges into a breakout room like we've been doing so they can discuss. And then once they're done, I'll bring them back in here. But for now, you can take a deep breath. Competitors, our judges are about to come back into the room if you'd like to turn your cameras back on.
Okay, it looks like we have everybody back. And thank you all so much on behalf of all of us, the opportunity to participate in this competition. We certainly appreciate it. Mr. Phillips advised that we're supposed to keep you all in suspense for a few moments. Anyway, I will tell you, and, as my colleagues will as well, it's a very difficult decision for us. I'll say this, and at some point, I may get over saying this, but I wish that the presentations that I see every day in my courtroom were as well done as how you all performed today. You were all very, very impressive. Your command of both the record and the law is commendable. And this is a difficult subject, to put it mildly. I'll confess, again, my own ignorance. I struggled to comprehend much of the substance of this packet, and took more work than normal. But how you all did was it was very impressive. I'll leave it at that. But with that said, going in the order of, I'm not sure what order. I'll go to Judge Volk, my district judge companion down the Southern District.
Thank you, Judge Clee. Irrespective of who wins this competition, each and every one of you, to reach the finals of a competition with so many teams is an astounding accomplishment. And to do so with the difficulty of the subject matter, I've been poking around federal court my entire career, 26 years, dealing with all sorts of complex issues, environmental, to bankruptcy, to mass litigation, tort litigation. This is as tough as it comes. And the way that you handled not just your argument from the standpoint of controlling the ball, so to speak, but how you reacted to the questions, retained your poise, pivoted even when we were ganging up on you. It was just fantastic. And just all four of you should be so proud of your performance. I know that we are.
Judge Alloy, sir. You're on mute, sir.
That's embarrassing.
There we go.
There you go. All right.
I apologize for that. I'm Michael Alloy. I don't know if y'all know who we are. I'm a United States Magistrate Judge for the Northern District of West Virginia, and I answer to Judge Clee, who's our district judge. I happen to teach appellate advocacy at West Virginia University Law School as an adjunct. And I really do have to say, collectively, I've never seen any better arguments. This is a hard problem. It was painful to read, and for you all just to keep at it, it's pretty amazing. I mean, someone should acknowledge that for you, right? I mean, it was, we talked a little bit earlier. I think you should just let the dormant clause lie. I mean, who wants to get into that? But, right? I mean, what a name to give a clause. But anyway, there we go. That's what they do. But you all were just so outstanding. Judge Clee's so right. All you want is a judge, because you don't go into it who should win, who should lose. You want lawyers who can help you understand the law, help you understand the facts, and help you do your job as a judge. I don't know how anyone could have done that any better today. So when you do that, you've done your job. And you can't control the facts in the law. That's out of your control. Could not have asked for better presentations. All of you had a little different style. Remain true to yourself. Some are a little more affirmative, others are a little quieter, little people have their own style, and as long as you stay true to yourself, all of them can be effective. But y'all should be really just proud of yourself where you are. I think they told me it was 38 teams this year. That's a lot. In addition, to do this virtually, I hope y'all had a chance to see people in your careers or yet. I mean, yeah, I feel bad because it's been a year and a half now. So if you're second years, um, you haven't got to do much of that. So really impressive. So again, thank you for being part of the West Virginia's law school's competition, and you represented your universities extremely well. Should be proud. Thank you.
And so that everyone knows, Judge Alloy has been saving that dormant commerce clause remark
Yes.
for some
Hey,
time now. So
Judge, I mean, it's not like you can bring it up at social occasions, right? I mean, you
That's
can't
right.
bring it up at
Right.
football games.
my kids don't appreciate a good dormant commerce clause discussion.
And I think frankly, all of us hope that it got more laughter. So that's a little disappointing. But anyway.
Yeah, I mean, right? No, it's all right. You'll learn that after a while that whatever a judge says is very funny. So anyway, that's right. That's right. So,
Well, let me just
All
bring
right.
it here real quick.
Yeah.
There you
Thank
go,
you, Judge
Mark.
Alloy. Thank you. Judge Abelhausen, sir.
Yeah, so coming up last, everybody else has taken all the wonderful things I wanted to say. I am Judge Omar Abelhausen. I'm in the Southern District, West Virginia, and I answer to Judge Volk. So you got 2 Southern District judges and 2 Northern District judges here, but nonetheless, you all did a fantastic job. I sent an email out earlier in the week to all the judges to tell them, look, I don't understand this topic. I'm not going to ask you questions. I'm going to be Judge Thomas and just sit there and be quiet, let everybody else ask questions. Of course, you notice I ended up asking questions, but very complicated topic. This competition always has a very complicated set of facts and law to deal with, and it's always above my pay grade to understand it. But I did understand it. I do have solar panels on my home, and so I understood the net metering, and that's why you got some questions on that. I nailed some folks on trying to get to the bottom of that. But anyhow, excellent job. You all should be very proud of yourself. And to say we picked a winner it's a skin of the teeth. There's no one, neither side was so dominant. Well, that's not the right word. Neither one was so much better than the other. You all was so good that it really comes down to the width of a hair as to who wins this competition.
Something Judge Abelhausen understands well.
A
And
width of a hair is a lot for someone like me. So,
and we were not permitted to declare a tie. So
No. Well, thank you. Anything else from my esteemed colleagues?
good.
All right. Thank you all. Thank you all very much. And again, thank you all for participating in this tournament. All of us, of course, serve here in West Virginia. Our only law school in the state is WVU, so it's a place near and dear to all of our hearts. And we certainly you enriching WVU's College of Law by participating in our tournament. But without further ado, and by the slimmest of margins, as Judge Abelhausen referred to, the winner of this year's competition is the state of Vandalia. So heartfelt congratulations to all of you. And thank you also to Commonwealth Energy. Again, you guys did an amazing job. Everyone did. It was as crazy as this sounds. It was an entertaining argument, despite the subject matter being incomprehensible to somebody like me.
Thank you.
Thank you, judges, and good job, Team 34. You guys did amazing.
Congratulations. Thank you.
Thank you.
Thank you to our judges once again. Huge congratulations to both competitors. I'm sure the school will be in contact with you all to get your information and probably get a picture of you. We can send you your award. Unfortunately, we can't be with you in person to present that to you, but we are truly so proud of you. And you did a great job. Thank you.
Okay. Thank you, Bryce.
Thank you.
Thanks, Bryce.
Good luck to you all.
Thank you.
Yes, best wishes. Enjoy March Madness. Go Mountaineers.
That's right.
See you. Bye-bye.
Bye-bye.
Thank you.